So the state's requesting a final order. There's several ways that this, apologies, Your Honor. So I think there's several ways that this could go. I'm not sure that Dr. Gaunt and I are in complete agreement. I think the most fair thing for his client would be to start the new child support June 1, 2024, which is the first day of the month after the service of Mr. Ferguson. I think the sticking point that you might need to sort out is that there's some I believe unreimbursed medical that Dr. Gaunt has pled for and is wanting addressed. My issue is I think the court knows the financial system that we have. It requires me to take a judgment before a new obligation commences. So if the new obligation is to begin June the 1st, then I would be requesting to confirm he's paid ahead as of May 31, 2024. And I show that Mr. Ferguson, as of 5/31/2024, was paid ahead $1,379.26. So anyway, I think that's what I have. If the court wants to leave the start date of the child support alone, or pick a different date, I'll be requesting a different arrears confirmation.
All right, Mr. Gaunt, you pled for unreimbursed medical expenses. Go ahead and tell the court what you asked me on that. Did you notice, Dan, about those? And anything else you're requesting we do here today, sir? Thank you.
Thank you, Judge. For the record, yes, I am present with my client. This is the third time we've come up here. Yes, we're asking, I've spoken with the state. They want to make the child support retro back to last spring. I'm fine with that. We have pled for unreimbursed medical to the tune of approximately $1,315. That is current as of, I believe, the last month or so. I can address that in a moment if I need to. We are also, if the court wishes to hear about it, asking for about $1,240 worth of unreimbursed travel expenses, and let me address that and I'll carve it back. We're asking that the standard travel provisions be put into this order. You'll hear some testimony from my client for a moment. This individual is not here today. This is the third time they have failed to appear. They did file an answer. I suspect my notes indicate that they did back in around Christmas time of 24. Okay. They have persistently failed to appear in these matters. I will be asking for attorney's fees, the amount of approximately $8,000. We're fine with the child support amounts, and I've spoken to Mr. Diamond about making that retro and whatnot. If the court wishes to, we have fought for the unreimbursed medical. If the court wishes to pursue that, or it's going to create a problem in the AG's computer system, to be blunt, I don't mean to sound like one of my mentors, but asteroids don't concern me. If I have to go after this individual in district court for this unreimbursed medical, then I will do that. I will ask the court allow me to remove this case to do that. I'm grateful for whatever we can accomplish today. I'm also almost certain that it will accomplish nothing. This individual has not paid, has persistently not paid, has persistently refused to show up for court, has persistently dodged service on at least 3 occasions. So this is just going to keep on trucking. But whatever the court can do today is fine, and my client's prepared to testify as to some of that.
All right. Well, again, I've got a strange feeling that the starting the child support last summer is probably going to be a lot more than the 13, 15 that you're looking at as well as unreimbursed medical. So I'll let you parse.
And that's why we're kind of not.
Yeah, parcel that out.
Yeah, that's why we're not standing on that one.
And y'all can go ahead and ask for that in district court if you wish. Yeah, because I got a strange feeling it's a lot more than that. So yeah. But anyway, anything else, Mr. Gunn? Okay. And of course,
negative, just that we will be asking for
anything else. Okay.
Understood, Your Honor. Thank you.
All right. Ms. Lambert. And again, I apologize. I thought this thing said August, but again, this stamp is just really, really bad. Y'all telling me it was December, then yeah, no problem. Thank you. Ms. Lambert, your motion to withdraw, ma'am.
Yes, Your Honor. So I was appointed by this court under SCRA to represent Mr. Ferguson. I was able from his pro se answer, which I think was filed in August of 2024,
Okay.
to I used his email address, phone number, and address from there, and was able to reach him via email and phone. However, during our initial conversation, much like Mr. Gann has described here, he's uncooperative. So he did not want counsel. He did not want to take my legal advice. So what I did was send him via certified mail a copy of all the pleadings and petitions that have been filed so far. I sent him from the Bell County website what has happened in the case so far, so he would be aware of any court dates up until that time that had been set, and it came back to me unclaimed. So per his request that he not be represented and his lack of cooperation, I'm just asking to withdraw.
All right. Any objection from counsel?
None from the state, Your Honor.
If there's a negative number on the objection, I have it. Otherwise, I'm happy to her withdraw.
I'll go ahead and grant that. Obviously, he's not invoked a service member, so I'm gonna find that he's pretty much waived that at this point, because again, I didn't know about his answer and everything. But the bottom line is, yeah, I'll go ahead and allow you off on this when you fulfill your duties. You do need to send him a copy of the order showing that you were allowed to withdraw Ms. Lambert. And I'm allowing you to leave the hearing at this point, and we'll go ahead and take up everything else, with you being officially withdrawn and him not appearing after filing a pro se answer and after getting proper notice. We're going to go ahead and proceed in default against it. Thank you very much, Ms. Lambert, and you're free to go.
Thank you, Your Honor.
Yeah, send me a final bill on that one. Thank you.
Yes, sir.
All right, this time I'll go ahead and ask Ms. Ferguson to raise her right hand, please. Ms. Ferguson, do you solemnly swear or affirm your testimony you're going to give this court today is the truth, the whole truth, and nothing but the truth to help you?
Yes, I do.
All right. Thank you very much, and I'll let the lawyers figure out who's going to ask the person. You want to start it out, Mr. Diamond, or are you going to let Mr. Gahn do it? Thank you.
If I could offer my pay record and then I would hand it over to him, Your Honor.
All right, go right ahead.
So I'd offer, and I apologize that it's not been marked, but I imagine the court will mark it States 1.
This is marked as State's Exhibit number 1. Any objection to it coming to evidence at this time, Mr. Gahn?
Negative.
All right, States 1 submitted, and I'll allow you to go ahead and proceed with your client, sir. Thank you.
Are you over to me, Judge? I apologize.
Yeah, I'm over to you. Yeah, thank you.
Ma'am, would you state your name, please?
Katie Ferguson.
And you are the custodial parent of the child in this matter, is that right?
Correct.
Okay, let's back up a little bit. We have filed to enforce some unreimbursed medical today, is that correct?
Correct.
And is it true that you have provided me with a spreadsheet that totals that to date, or within the last couple of days or week or two, as being approximately $1,315, is that correct, of unreimbursed medical?
Correct.
You've had to hire me to prosecute this case on your behalf, is that correct?
Correct.
And as many conversations as we've had over the years, and as much as I'm sure you enjoy my time and my company, I've had to charge you for that, have I not?
Correct.
Is it true that you have incurred approximately $8,000 in attorney's fees over the course of this case?
Yes, it is.
Just on this matter, we're not talking about the divorce and all the preceding
Right,
things.
yeah.
Okay. Now let's talk about a few things here. Your child, the child y'all share together, she is, among other things, in therapy for a few things, is she not?
Correct.
Is it true that the respondent father has canceled that therapy and revoked his consent for it?
Correct. Yes, I
Has
was
that
notified.
Go ahead, please.
Yeah, they called me in late May to notify that he had called them to revoke his consent.
Has that caused you additional time and expense to put in a new therapist for this child?
Yes, I had to resort to other means and insurance that would not cover it. So it's much more expensive than what it would have been before.
Let me ask you this. You heard the state's testimony that they're asking for guideline child support and to make that retroactive back to last May, I believe. Is that correct? You heard that?
Yes, I heard that.
And you and I have discussed that. Are you also in support of the state doing that today?
Yes.
Okay. Now let's sidestep slightly. One of the things we are asking for, if the court contemplates it today, are we asking to put the standard travel language in that he has to give you a certain amount of notice on travel?
Yes.
Is it true that is it true that we're asking that to be 30 days notice?
Yes.
Okay. Has he canceled flights before?
I mean, he canceled his trip in July, which made me cancel my flight, my return flight to go get her.
Huh?
So yes.
And is it true that you incurred approximately $1,243 in cancel fees and canceled tickets for that?
Yes.
If the court contemplates it within this possession and access order, are you asking for the exclusive right to maintain the passport?
Yes.
Okay. Now I know we're here on child support and we're here on medical support. He is active duty military, is he not?
Correct.
Okay. And so you are asking, number one, that the court find guideline child support and make that retroactive. Is that correct?
Correct.
We have been trying to serve this individual for quite some time. Is that correct?
Yes.
And as I understand it, this is now the third hearing we've had to come up for in regards to this matter. Is that correct?
Correct.
Okay. You are asking for attorney's fees in this matter. Is that right?
Yes.
Okay. If the court deems it appropriate, do you have you have a spreadsheet and you have the documentation in regards to these medical expenses? Is that correct?
Yes.
If the court were to do this, if the court were to um, ask for further proceedings in this matter, are you asking to appear by video?
Yes.
Okay. You are out of state, are you not?
Correct.
And I believe you are in
I'm
North
in.
Carolina. Is that correct?
Correct.
Okay. And he's in out of state as well. Is that correct?
Correct. He's in Kentucky.
Okay. Are you asking that whatever judgments and garnishments the court finds today, are you asking that those be garnished from his pay?
Yes. Wherever they need to take it from.
Okay.
Because
Obviously, we've dealt.
he will
Go
not
ahead,
willingly
please. That was
pay.
my question.
Yeah, he will not willingly pay, and more than likely he will call and yell and harass me about it when he finds out.
Well, it's going to go straight to DFAS and be taken out. So
Yeah.
yeah, I can't do anything about him being a jerk about it, but yeah, luckily so long as he's in the military, he should be able to get this. So I'll go ahead and let you proceed, Mr. Gaunt. Thank you.
All right. So, in regards to the medical support, in regards to medical arrears,
I'll tell you what, Mr. Gunn, on this, I'm gonna go ahead and let's bifurcate the medical arrears out. I'll reset you for next month. I'm ready to go ahead and rule on that and grant that. But let's go ahead and let the state get a final order in doing their paperwork. Come back next
understood.
month, and that way you don't have to file anything new in the district court, and we'll come back and
Okay.
we'll slam dunk that one.
Let me ask you this. Okay, let me ask you this, Your Honor. If we can address that, if I would prefer to address it and submit documentation electronically if I can, but that way I'm not
let's do
taking.
it. Let's do it that way, and we'll
Because
give him notice of that hearing also. By then, he might show up because he's going to figure out that things are moving forward against him. He might not like, but we'll see. All right.
Ma'am, in the previous order, I know the court's listening to this today, so let's just talk about it as long as we're here. In the previous order, your daughter she's how old? 5?
She's 4.5. She'll be 5 in January.
And it was maintained that per FAA regulations that she could fly unaccompanied at age 5. Is that correct?
Unfortunately, yes.
Okay. In fact, as I recall, we had a hearing about that, and myself and another attorney had to look up the FAA regs on that. Do you recall that hearing?
Yeah, it was
Are
the
you
503 hearing.
Okay. If the court contemplates it, are you asking that that age of unaccompanied flight be changed
Yes.
to how old, ma'am?
I used to
9,
always use
10.
8. I used to always use 8. I didn't know it was down to 5. I didn't think they did that. Sorry about that one. That's good to me
It
too.
is. If we want to use 8, I think that would be fine.
Yeah,
But
I would be okay with 8.
Yeah.
that's
Okay.
fine, Judge. Yeah, Judge. Judge, that's all I have of my witness. At this point, I'm touching on testifying directly, and I was just going to do that as an officer of the court. So if I can address the court when we're ready.
Yeah, okay, I'm ready. Go right ahead.
Judge, I would ask, although I think you have, I would ask the court to take judicial notice of the file. If I may testify as to attorney's fees, Your Honor.
Go right ahead.
Good afternoon, judges. I'm sure you're aware, and probably everybody listening is aware. My name is Dr. N.J. Gott. I am the senior attorney and managing attorney of the Pritchard firm. I have been licensed in this state since 2009. My bar number is 240697771. I have been licensed in this state. I am licensed in multiple federal jurisdictions, including for the United States Supreme Court. I am a member of the State Bar College. I've been a candidate for board certification, a member of 2 different state bar committees. The thrust of my practice is family law. If the court wishes to receive it, I have an exhibit that I can prepare and present in regards to the billing, but let me just be direct. At this point, as of today, not including this morning, which I would say is probably another 2 hours, my client has incurred legal expenses in the amount of $7,910. There's been about, let me pull it up. There's been about 25 hours worth of billing. I've got to the point at this point with this respondent who has been so uncooperative that I have actually started non-billing some of it because I'm just trying to get this my client to court. She needs to have her day in court. She's been exceedingly patient through no fault of her own. And so, if the court will give me just 1 second, I apologize. I will give you the breakdown on that. But I do feel that those attorney's fees are appropriate for an attorney of my experience. My hourly rate is $400 an hour. Again, I've practiced in this area extensively and also in Austin and the Dallas-Fort Worth area. And let me get this more specifics on there. I apologize, Judge. To date, we have billed, yes, 25 hours. The total has been 32.2 hours. We've invoiced 31.3 and non-charged about 7.5 hours. I'm rounding off slightly and not counting today. Again, we've gotten to the point where this lady needs to have her day in court, and I've started non-billing stuff just to keep Kate going, just so she can come in before you. I think the award of attorney's fees is very appropriate. This individual has dodged service on 3 separate occasions: February 11th of this year, October 24th of last year, and also August, or I'm sorry, I apologize, on 2 separate occasions, October 23rd and February this year. At one point, somebody representing him or claiming to be him, a member of his family, lied to my process server and told him he didn't live there. So he's done everything he can. He's an active duty service member. He certainly I would assume he has a security clearance and is under a lawful order to comply with orders, including the orders of this court. And quite frankly, he simply doesn't care. Nothing's happened to him. We had been asking for coercive contempt, but quite frankly, he's no good to me locked up. But again, if it wasn't clear before, I have less than zero faith he will pay this. He is going to continue to obstruct this. He's going to continue to obstruct this court's order. He's made it very clear to my client that this child is not his priority, but making her life miserable is. And at this point, I feel that child support, of course, is appropriate. Medical support is appropriate. Attorney's fees are appropriate. And I'm asking for you to make that. And although we're stepping out of it slightly, I am asking the court contemplate the provisions in regards to standard passport language, giving her the exclusive right, modifying the age of the child. This individual, quite frankly, has just sat there and let the order and thumbed his nose at this court and at my client. And I don't think there's any actions anywhere present, even including the testimony from Ms. Lambert, that this individual is doing anything in regards to the best interest of this child. So I think any and all relief the court can grant today is appropriate. Thank you.
All right, this time, Mr. Gunn, I'll go ahead and count your request as a trial amendment under the Texas Rules of Civil Procedure. I will grant it. The father has been placed on numerous notices to be here. He has filed an answer, and with that comes responsibility of him actually appearing. If you file a pro se answer, even though you're not a lawyer, you get notices and you need to show up. So I will grant your request as a trial amendment at this time. I'm going to go ahead and the court, I hear attorneys and attorney fees all the time. A modification with slightly contested issues should never run more than $3,000 in attorney fees. So at this time, I'm going to grant you $5,000 in attorney fees on this matter and make those due and owe to you strictly through from him. I'm going to go ahead and grant the new child support amount. We're going to start Mr. Diamond, we're starting at I'm sorry, was it July 1 of last year or June 1 of last year?
Requesting June 1, Your Honor.
Okay, July 1st of 2024 at the new amount. I'm going to hold in advance of finding on the requested unreimbursed medical expenses and reset that for another date and bifurcate it specifically out of this case to allow the state to prepare a final order dealing with this issue and these issues, and let the state get their judgment and repayments and everything that is necessary under their order. I'm going to go ahead and grant the mother exclusive rights to the to the passport of this child. I'm going to go ahead and modify. Let's not use the 5 years old is too young to be flying unaccompanied. I'm sorry, that's scary to the court even. So I will order that, and the child reach a minimum of 8 and 8 years before that can happen. And I'll go ahead and ask the state to prepare this order and to get this done. And we'll ask Mr. Gordon, I'll look at a date going forward. We come back on the single issue I'll be looking at on that time. I'm making everything else final. Single issue I'll be looking at on that date and we'll do it more 30 days out. So this becomes final. The single issue we'll look at on that date is the unreimbursed medical expenses at that time. Anything else that you requested I do here today, and then I'll go to Mr. Diamond about his circumstances. Thank you.
Judge, at the risk of stealing defeat from the jaws of victory, the trial amendment you're referring to, are you referring to my attorney's fees or the other relief request?
I thought the attorney fees were planned for. I was talking about the
okay.
I was thinking about the 8 years old traveling and the passport. If that wasn't
okay, understood. That's
decided done earlier, then those are just two clerical items that could be easily handled by a trial amendment. Sir, thank you.
Judge, I'm going to ask for one other little minor thing. It is a housekeeping matter. If it isn't already, can we put app close or something in there in communication? I think it's already in there.
If it's not, it needs to be, and the court will look at that being the official way of communication. Ma'am, you need to set up the app, send him the right to join it, but based on the prior history of this gentleman, it may or may not happen. But that's the one that's going to be any official notices, anything dealing with this court order that it requires one party to put the other on notice. I'll allow you to do it through app close, ma'am, and that includes sending them copies of the medical unreimbursed medical expenses, that sort of thing. You can do that all through app close. It's got that ability. It's got the ability to text, and I recently had and FaceTime and all those other things. And recently I had to have a lawyer brought in the transcripts, everything based on app close, and it really fit into the court's file just perfectly. So yeah, it's actually a great way to document things. So it really works. So I'll ask you to go ahead and do that now. Yeah, go ahead. I'm sorry.
Does the court contemplating make the Bell County Standing Orders 2.1 and 2.3 a standing a permanent injunction?
Yeah, you can go ahead and add the standing order at this time to this matter. Yeah, the latest thing. I think the newest one replaces the old one. So, or if you need both of them in there, go ahead and do it. But I'll go ahead and grant these standing orders.
That's all I think I have, Judge. Thank you. And I'm sorry I cut you off.
I do want to go ahead and add that I normally waive court costs for military persons, but based on this gentleman's cooperation with Ms. Lambert, I'm going to order court costs and reimbursement of her expenses. I'll leave it up to the clerk to put it in there, but I'm going to order this gentleman to pay court costs in this matter also.
Yes, Your Honor. So the wording is that the standard court cost language, and then do you want a note in there specifying that even though he's despite him being military, that his lack of cooperation?
You don't have to put that in there. Just saying the court have granted the order that any and all court costs be the responsibility of the non-custodial party. You don't have to put that in there. Why? Just the fact that I did it. Okay, that's all.
Yes, Your Honor.
All right.
all I got, Judge. Thank you.
Anything else, gentlemen?
Yeah, a couple other questions, Your Honor, please.
All right.
So the first, my request was well, I say confirm arrears, but a ruling that Mr. Ferguson was paid ahead $1,379.26 as
That's
of
the 30th of May of last year, correct?
31st, please, Your Honor.
First, I'm sorry, I got the day. April has 30, May has 31. Okay, yeah, go ahead. I'll grant the judgment as of that date that he was paid ahead. Yes, sir.
And then there were a couple other requests that I heard Dr. Gaunt make that I might have missed a ruling on. I think Dr. Gaunt requested 30 days notice on future travel. Was there a ruling there?
Okay, did you request? I'm sorry, I may have missed that one. Did you request that? Okay, okay.
We did, Judge, because he keeps changing things at the last minute and doing things, and I'm trying to where my
let's
client's
go ahead
not.
and grant. Yeah, everything has to be 30 days advance notice, and everything has to be finalized at least 30 days in advance. And that way, mom can get it locked in as
And then-
much as possible. If he sounds like he keeps he may be buying the tickets that he's allowed to cancel and get his money back, and she didn't. So yeah, that I've had people do that in a couple of my cases just to mess with the other side. So yeah. So you might, ma'am, I know it's a little extra expense, but you might want to pay the extra because that may be that may be something he's doing in this one too. So he got all his money back, and you're stuck. So yeah, the games people play. Next, Mr. Diamond, thank you.
And then the other request that I didn't hear a ruling from, Your Honor, of Dr. Gaunt's, I think the testimony from Ms. Ferguson was that she incurred $1,243 in fees and other expenses because of Mr. Ferguson canceling
That part
visits.
I didn't think was a request for reimbursement. I don't remember. I remember him telling me that, but I don't think that was an official request for reimbursement.
It was.
It was okay. That one I might need the paperwork on, Mr. Gaunt. I can hold that one in advance, and we can take that up with
That's fine.
reimbursed medical expenses. Okay,
That's fine. Thank you, Judge.
not a problem.
I have one minor question if Mr. Diamond's ready.
No, yeah, I'm ready, Your Honor.
Okay. Are you addressing me because I'm not a judge anymore?
All right, yeah. Is that it? Is that it, Mr. Diamond?
That's it, Your Honor.
All right, Mr. Gaunt.
Judge, if you're gonna maybe not. I guess maybe get a court date. I was gonna say if you're looking at doing a court date about a month out, I think I'm before you on the 23rd of September. So
That's not quite 30 days. Let's make it 30 days, but this one becomes final, and we can take up the issues that I bifurcated out on a date after this becomes
I think
final.
I'm here on the copy of that. I think I'm here on the 7th of October if anybody cares.
Okay, let's reset it to the 7th, and mom's allowed to testify doing in Zoom again. No problem.
Copy. Thank you so much.
Not a problem. All right. Well, of course, judge with his family background, anywhere near Fayetteville, ma'am?
We didn't copy your audio.
Ms. Ferguson, anywhere near Fayetteville?
I'm currently in Fayetteville.
Okay, so it sounds like you may be somebody there near you may be 82nd and he may be 101, but yeah, cousin George was 101, but dad was 82nd, so we're gonna go with that every time. All right, not a problem, man. I just want to make sure. I was just it's just something that popped up, so never mind. Thank you. All right, anything else? Gentlemen.
None from the state, Your Honor.
All right. See you in
Yeah,
October,
Judge.
and we'll take up the issue of the unreimbursed medical expenses and the expense for last minute cancellation of the airline circumstances. And again, we're going to make that we're going to change that around in the current final order to make sure that that can't happen in the future. As well, we're going to mitigate that as much as possible by ordering that there'll be 30 days notice on that ahead of time. All right, not a problem. All right,
Copy
thank
that.
you
Thank you,
all
Judge.
very much. And we're off the record. Good luck, ma'am. Good luck. Well, no one else is here. So and we'll see you in October. Thank you. We're off the record.
Thank you.
And
Thank
I got to
you,
finish
Judge.
writing this
Ms.
one up.
Ferguson, you're free to go.
Let me finish writing this one up, Mr. Diamond, and I'll be ready to go on the next one. Thank you.
Okay, thank you, Your Honor.
Judge, may I be excused?
Yes, you may.
Thank you.